Good afternoon.
Well, hello everybody, and welcome to this latest PodCosts, or as it used to be known, Cost Chat Between Friends. The usual suspects are Andy Ellis, Managing Director of Practico, who's here with me, and me, Jeremy Morgan, retired cost silk and current consultant to Practico. And our guest today, who I'm really delighted to welcome, is a very old friend, Ben Williams, KC, a four new square, who is literally at the top of the tree in terms of cost silks. So we very much welcome his presence and look forward to hearing what he has to say about the topics we're going to discuss. Before we get into that, I should mention that there is a rival PodCost that's been set up by another costs lawyers agency. And if you've switched on to see that, you're very welcome. Please stay. This is Practico's podcast, and we hope you enjoy it. In future, for you and anyone else, if you want to know you've got the genuine article, you'll be seeing me and Andy and either a top cost silk like Ben today, or a cost judge, or someone very eminent in the profession of costs. I'm going to pass over to Andy now very quickly to summarize how you can find the content on the website if you're catching up.
Right. Thank you. Easy, actually. The easiest way to do is to look at our website, which is www.practico.co.uk. And you can also look on the main, you can look on YouTube and put in search terms like Practico or PodCost, and we ought to crop up. But easier than that, because we disseminate links to this on our extensive mailing list, we put links in there. And then once you've found a link to Spotify or SoundCloud or wherever you get your podcast from, it's then easy to subscribe if that's what you would like to do.
And we hope you will continue to do so in the future. Our topics today are, the main one is going to be the case of PACCAR, which we've dealt with a couple of times before, but it's an ever-changing field as a consequence of PACCAR, and we're going to look at that. A look at a Court of Appeal decision on ADR, and a brief mention of new guideline hourly rates, and a very brief look at what's happening with the Solicitors Act. But dealing first with PACCAR, I'll hand you straight over to Ben Williams.
Yes, thank you, Andy, Jeremy, and hello, everyone. Nice to be back. So PACCAR, I know it's been spoken about before, but I'll just give a general introduction for people who haven't been following it. So PACCAR is a case from the Competition Appeals Tribunal. It's one of the opt-out collective proceedings actions, which, if people aren't familiar with those, that's a new form for mass redress in a competition context, which has been developed in the CAT, where essentially a person can appoint themselves class representative, and they will thereby represent everybody in a class, which might be extremely large, like customers of MasterCard in the United Kingdom since a particular date. And if the CAT approves them, they can bring a claim on behalf of everyone in the class. People in the class will have no involvement in that at all. They won't necessarily know they're represented, and it just enables a sort of mass redress, as I've said, to be conducted in a way that is so much more streamlined and involves so much less book building, for example, than a group action in the courts, where you do have to sign people up, and that can be a mammoth exercise. And the received wisdom is you will only ever pick up a very small proportion of the overall cohort, save in very specialized cases. So it's a very interesting development, and it's leading to some absolutely titanic cases worth billions and billions of pounds in the CAT. Unsurprisingly, defendant interests are doing all that they can to strangle them at birth. It's already been up to the Supreme Court on some issues around the scope of the jurisdiction. Steady stream of appeals to the Court of Appeal, but what we're here concerned with is an attempt to derail the way in which the proceedings are funded, because obviously to bring mammoth claims of this sort, no class representative, unless perhaps for some reason the Duke of Westminster gets appointed a class representative, is possibly going to be able to finance it himself or herself. So it's all about litigation funders. And one of the curiosities of the Competition Act regime is the government decided they didn't want to see lawyers get rich out of it, or at least not any richer than they would out of their usual hourly rates. So in a late amendment to the legislation enabling this new scheme, they banned damages-based agreements from competition cases. All well and good, because litigation funding was available, you didn't need DBAs. And then suddenly a defendant said, well, hang on a second, litigation funders, they get paid by taking a percentage of the damages. Why aren't those damages-based agreements? And everybody sort of scratched their head and said, well, that's ingenious, but it's perfectly clear the government did not intend to regulate litigation funding under the DBA regime. There's a different legislative regime for litigation funding. Obviously, that can't possibly be what the legislation means. Robust decision of the president of the CAT agrees. A strong decision of the Court of Appeal also agrees, goes to the Supreme Court. Justices split 4 out of 5, reversing the lower courts, taking a very narrow black letter approach to the law. Some would say blinkered. Yes, these are DBAs, and therefore litigation funding agreements of the familiar sort, you take a percentage of the damages, are unlawful or at least unenforceable in competition cases involving this new opt-out regime. Obviously, to put it in a slightly 1950s metaphor, the balloon goes up because that sort of causes the way in which all these cases are financed at the moment to collapse. So chaos results. I can tell you that it's a decision which even within the judiciary has caused extremely strong feelings. I've heard a number of judges frankly say the Supreme Court took leave of its senses. Obviously, they don't say that in court, but they're happy to say it outside court. A very controversial decision. Now, Stop Press of a week or two ago is the government, as the Digital Markets Competition and Consumers Bill is going through Parliament, said, oh, well, we're going to amend it. And they're going to do something very radical, very rarely happens. We are going to reverse PACCAR with retrospective effect. We are going to amend the prohibition on DBAs in opt-out collective proceedings, so it does not apply to litigation funding agreements. And we will include in the provision a deeming provision that says this amendment is deemed always to have been enforced. That's how it becomes retrospective. So, I mean, in some senses, it vindicates everybody criticizing PACCAR because it shows what everyone's been saying all along, that the Supreme Court, under the guise of doing what Parliament intended, in fact, has managed to do precisely the opposite. So radically opposite, Parliament rushes through emergency and practically unheard of retrospective legislation. But I suspect one of you is going to ask me, Andy or Jeremy, are there any problems with the legislation?
Are there any problems with the legislation, Ben?
There are some quite serious problems with the legislation, Andy. Really, there are 2 points to the way in which it's currently drafted. I mean, again, I don't want to descend too much into the technicalities. Firstly, because I suspect most of your viewers and listeners would be interested more in the bigger ticket points. And secondly, other people have spoken on these podcasts about it before. But the way in which DBAs were found to extend to litigation funders is DBAs also extend to providers of claims management services. Now, claims management services had always been understood to refer frankly, and I think knowing your demographic, I can be pretty blunt here because I don't suspect any of them will be viewing, to the kind of bottom feeding claims management companies that run sort of the sort of lowest end fast track road traffic cases, the sort of mass market PPI claims, things of that sort, never thought to extend to people who were supporting sort of billion-pound litigation in the CAT or the commercial court. But the Supreme Court says, well, that's claims management services. So the way in which the government thinks it's neatly amending to avoid this problem is it declares that the prohibition on DBAs in the Competition Appeals Tribunal opt-out collective proceedings will only extend to DBAs for legal services. So they take claims management services out of the equation. But there are 2 ways in which that simply doesn't work. In a narrow sense, it simply doesn't work insofar as they're trying to make it retrospective to redeem all the funding agreements which are now unenforceable. Because although it removes the ban on DBAs being used by funders in opt-out collective proceedings, it doesn't alter the fact that they are DBAs, they're just no longer prohibited DBAs. So because they're still DBAs, the funders still have to comply with the DBA regulations. And of course, none of the funders have complied with the DBA regulations because it was universally understood that they didn't need to. So the way in which the government proposes to do it fails at what I'll call the micro level, because it in fact still leaves the agreements all unenforceable, but for a different reason. Not because they're simply banned in opt-out collective proceedings, the ban is removed, but they're all still unenforceable because they haven't complied with the DBA regulations. So that is completely hopeless. But it's hopeless at a macro level too, because this problem about DBAs, for the reason I've just given, that none of them have complied with DBA regulations. When I say none of them, I mean no litigation funders. That obviously applies equally to DBAs being used in mainstream litigation, or litigation funding agreements that are being used in mainstream litigation. So all the litigation funding agreements that are present out there in the TCC, the Commercial Court, the Chancery Division funding big commercial cases, they aren't helped by this amendment at all because it's only directed to CAT proceedings, and they are all unenforceable because they haven't complied with the DBA regulations either. So it really is the most sort of profound missing of the target that really is possible to contemplate.
I was interested to see that the amendment is made by the Secretary of State for the Department of Business, when you'd expect this to come more from the Department of Justice. Does that explain, do you think, the narrow scope of the amendment? In other words, just opt-out collective proceedings in the CAT?
And I think it probably is right that they are at the moment slightly mesmerised by the local difficulty, which I call it that. Although that's a gross understatement in terms, given the massiveness of these cases in the CAT. But I think they have been mesmerised by seeing it as a local difficulty, not perceiving, in fact, there is a much broader difficulty. They clearly also have been mesmerised by thinking it is just the problem with DBAs being banned in the CAT opt-out jurisdiction, when that isn't the only problem. There's, as I say, there's the equal and freestanding and indeed wider problem, because it applies to all DBAs which are also litigation funding agreements inside and outside the CAT, which is that nobody has complied with the DBA regulations. So that just seems to pass them by. I think you may well be right that because it's coming from the Department of Business rather than the MOJ, that explains the focus on competition cases. I think it probably is also right to say that there is some concern as to the extent to which they can tack on a amendment which is other than a narrow and focused one into a bill which relates to competition. Can they use a proposed act about competition, in fact, to deregulate litigation funding agreements across the whole of litigation? Now, constitutional lawyers might perhaps speak more intelligibly on that than me. I mean, I, for my part, can't understand why they can't. I mean, it's perfectly normal for all sorts of bizarre things to be spliced or hybridized into acts which are mostly addressing other things. I mean, one thinks, for example, about an act about criminal justice which just has tacked on it a provision to introduce a concept of fundamental dishonesty in personal injury cases. So it certainly has been done before. But I think there's a kind of mixture of muddled thinking and a mixture of the concern about how far can they properly go by tacking something onto a bill about competition, when in fact it's a problem of far wider scope.
So do you think the well, I mean, obviously you wouldn't know, none of us know, but would you share my hope that the third-party funding lobby is sufficiently well armed to be able to get its message through before this bites the dust in a different way?
Well, I mean, what I think is certainly clear is the fact the government are trying to do something at all and aren't just saying, oh, we've got a lot of other priorities, small boats, inflation, sorry guys, it's just not sufficiently important. They're not doing that. So there is a will to tackle it. And obviously, there will be big business lobbies that would be delighted to see these mass redress consumer actions, as I said, strangled in their cradle. And the government clearly is willing, not to go out of their way to sort of do them a favour. So there does seem to be some political will there. However, I have been told by people who are sort of close to the process that the problems with the draft legislation were painstakingly spelled out to the sponsoring government department at a senior level, before they were promulgated, and it didn't lead to any revision. So I think one has to treat it as something which is up in the air. But I suppose from your point of view, looking at it from the perspective of trying to preserve the litigation funding industry, the fact they are proposing to do anything at all does tend to suggest there is a political will to do something about it. Yeah. Even as we cruise towards a general election and the government having 1,000 other things on its mind.
Yeah,
I was interested to see, I think it was in Legal Futures, a comment by Leslie Perrin, who's the former chair of the Association of Litigation Funders, saying they pointed out the original problem with litigation funding back in 2013, when DBAs were first being promulgated, and their concerns fell on deaf ears then. So it'll be interesting to see if the same thing happens, as you rather suggested now.
Yes, I mean, I think it is one of those things where everyone who looked at this point, admired the ingenuity of the lawyers that dreamt it up, clearly saw that you could join the dots in a way in which they were arguing the dots should be joined. It was clearly an argument that worked from first principles, but it was so obviously the opposite of what was intended. When the government legislated for DBAs in 2013, it is absolutely clear its intention was to legalise something which was previously unlawful. Its intention was not to illegalize something which was previously lawful, and litigation funding agreements had been found to be lawful at common law a decade before, and by 2013 in the fact-obtained litigation, and by 2013 everybody knew they were extremely common. So it is so nakedly clear that there was no intention by the government to bring them into the DBA fold, that everybody thought that in the same way that the Court of Appeal and the CAT itself had managed to find perfectly coherent ways through the statutory morass, that the Supreme Court would do the same. And there does seem to have been an extraordinary failure of pragmatism by the majority. One suspects that, I think it's been widely suggested that the Supreme Court at the moment is quite small c conservative. There does seem to be a deliberate rolling back from what some saw as the grandstanding of the black spider brooch years, and whether or not litigation funders have inadvertently sort of caught the bullet resulting from that process is above my pay grade, but you could certainly see how a theory could be developed to that effect.
Nothing is above your pay grade then. And what are the prospects of, I think Robert Buckland has put forward an amendment to the same digital marketing bill to provide for consumer class actions in the CAT for breach of the various regulatory provisions of that bill. Have you got any idea of the prospects of success of that particular amendment?
I don't have any sense of the prospects of success. I suspect you'd need to speak to someone who understands the what goes on in the corridors of the House of Commons, rather than a lawyer who's not also a part-time politician. And there are one or two of us who aren't. But it's a very, very interesting process because of and it takes back to the introductory remarks I made. The great obstacle to mass consumer redress in this country is that outside the CAT and this special process I've described, which has been introduced by legislation, we only have the concept of the group action, and the group action has the disadvantage, which I mentioned, that it involves the book building exercise, and you have to get people to sign up to it. Obviously you could call it inertia. There's a huge inertia in the system, in order to get the boulder, before you can get the boulder rolling, to pick up the consumer claims. And only a very small fraction of them will ever come forward, as compared to, as I say, something like the CAT, where someone can just, the president of the Consumers Association can say, everybody has been overcharged for railway tickets because of this particular deficiency in the ticketing system, which the train operating companies have all collaborated to maintain. And suddenly that is a class action brought on behalf of everybody who's bought a railway ticket in the last 6 years, even though the vast majority of them will never know about it. So it's fundamentally different. Now, there have been attempts, as you may know, in the courts to try to develop something similar. And the focus has been on the old representative action in Part 19, which is really an old Victorian procedure. It's a sort of relic of the Victorian Chancery Division, which was originally used for things like shareholders appointing a representative. So only one shareholder needed to bring an action in a company law case, say, rather than each of the shareholders being joined simultaneously. It was not a system that's in any way been developed with a view to the kind of mass consumer redress which I've just been describing. Now, the most prominent of those cases was Lloyd and Google, which essentially didn't get anywhere on the merits, and there wasn't really much exploration as to how Part 19 might work in a practical sense to do this. But most of us who've looked at it carefully think that there really are tremendous difficulties. And the biggest difficulty is, as I said earlier in the context of the CAT, these things can only work if you have litigation funders. Even the sort of firms that are well known for bringing group actions, lead A, say Michigan Direct, things like that, the extent to which they have got the resources without external investment to support mass consumer redress actions, is far from clear. So they need litigation funders. The difficulty you then have is if it's not an opt-in procedure. So if the vast majority of members of the class don't know the proceeding is going on, how can the litigation funder be sure it's going to get its return? Because there's obviously no contract between the litigation funder and the members of the class, precisely because it's opt-in and not opt-out. Now, in the CAT, legislation has addressed that, and the CAT has got power essentially to award the litigation funder its funding charges out of part of the damages which are recovered. But that's a statutory power. In the courts, there's nothing in the CPR that would facilitate that. So there are these sort of practical obstacles. So I appreciate it's an extremely long answer to your question, but I'm just trying to explain why this Buckland amendment is of great interest. If essentially all those arguments can be squared away by having a statutory scheme for consumer mass redress in the same way that you've got the competition mass redress, you eliminate all those issues and you do move towards a system in this country that begins to look more like some of the systems you have in places like Canada and the United States, where you do get these mass redress actions by consumers.
Unsurprisingly, since PACCAR was handed down, we've already seen one attempt by the defendant to pick up on it and use it to knock out a claim in the CAT. Do you want to tell us something about that? Yes,
that's a case called Neil, Alex Neil. Actually, it's a company because a lot of the class representatives in the CAT they incorporate in order to limit their potential liability. So it's Alex Neil Class Representative Limited, who's bringing a group action against Sony. And they had what I call a traditional pre-PACCAR litigation funding agreement, which took a percentage of the damages in return for the funding. Now, as a result of PACCAR, obviously you need to go back to the drawing board. What most funders are doing is they say, well, instead of taking a percentage of the damages, instead we could just calculate our return differently. We'll make it a multiple of the sum that we invest. So if a funder fronts £20 million, they may say that if the case settles, within 2 years, we'll get 3 times our investment. After 2 years, it goes up to 4 times. After 3 years, it goes up to 5 times. Things like that. So I mean, that is that's one way in which people have been going about it. What happened in the Sony case was not unsurprisingly, given that it was rumoured at that stage that the government might legislate to reverse PACCAR. They subjected their new agreement also to what I'll call a traditional agreement held in suspense, which essentially said if PACCAR is reversed, then our new funding arrangement is revoked, and we'll go back to the old funding arrangement. That's a very crude simplification, but that's basically what they provided for. And defendants tried to say, oh well, no, that means it's still a DBA because there are still theoretical circumstances in which the funder's remuneration could be linked to damages. Now, I think probably the case is more interesting for what it tells us about the attitude of the judges rather than the particular decision in the case, because I think, unsurprisingly, the tribunal, I think, which in many ways is just an emanation of the High Court. I mean, most tribunal chairmen in the CAT are commercial court or chancery division judges from England or Wales, or commercial judges from the Court of Session in Scotland, or very highfalutin competition or commercial silks who also sit as deputy High Court judges. So let's be clear, for people who may not know the CAT is just the High Court with a different hat on. It's a very, very high-powered institution indeed. So the CAT says, don't be silly. The agreement in its current state is not does not have a damages-related clause, because it, as the law stands, the agreement does not provide for damages-based return, and it simply has a suspended amendment that will come into force if the law is changed. So there's nothing wrong about that. I can't say I'm surprised at that result, but what I think you do sense from the decision is a real a real determination on the part of the judges to confine PACCAR so far as possible, not to be sympathetic to technical challenges, to try to make the situation work. Because I think most judges outside the four of the majority of the Supreme Court think it's a highly impractical decision, and the fallout from it needs to be minimized as far as humanly possible.
I think the other thing that's quite interesting, I think it was the last podcast, Alex Hutton mentioned various arguments that defendants were coming up with to knock out these agreements. And one of those was, well, even if you amend your agreement in the way that was done in the Sony case, the fact remains that the money for the lawyers and for the funder and everyone is still going to come out of the damages, because that's the only source it can be. So it's clearly, in practice, if not in contractual terms, linked to the recovery. And the tribunal really took a very dim view of that and said, no, you look at the contract, look at the contractual terms.
I have to be a bit careful, because I bumped into Alex at a conference a few weeks ago, and he tells me that he has been advising people on PACCAR, and he keeps being told, oh, Ben Williams said something different. But then the sort of mass of people sort of cantering out of the conference room to get to lunch sort of separated us by a human tide, and I've yet to find out what it is that we're allegedly differing on, and I haven't seen his podcast. So if I end up entirely disagreeing with him, forgive me. I mean, I think that it was an entirely predictable line of challenge, but it's obviously in the nature of these arrangements. Then I think the jargon is non-recourse. So in the real world, there is only one source from which the damages could come. But it doesn't surprise me that the courts or the CAT take a very dim view on the suggestion that the fact that in the real world there is only one pot from which payment can come is not enough to say that it's a damages-based agreement. I mean, the reality is, as you all know very well, there's all sorts of litigation not funded by DBAs where the only realistic source for the lawyer, for example, a lawyer's remuneration, is a cost order against the other side. But the suggestion that creates a contingency fee arrangement would be considered to be entirely heretical. I mean, that would mean arrangements which have been recognised by the courts and in fact encouraged by the courts, because described by the courts as praiseworthy for lawyers to sort of act in such a way to support people that don't have the funds to pay their solicitors up front, would be DBAs. What about the situation in, say, in personal injury cases, where under personal injury CFAs, by law, you have to limit your success fee to a percentage of the damages? Now, that can't possibly create a DBA, because the legislative regime for DBAs and CFAs are mutually inconsistent. So the government, or more precisely, Parliament, when it introduced the current litigation funding regime, and remember, post-Jackson, CFAs and DBAs, essentially, it's all reenacted on the same date, same piece of legislation. So they have to be construed in a way that the two regimes are consistent with each other. The Parliament must have decided that it does not create a DBA to have a CFA which by law must say my success fee can't exceed 25% of your damages, which is all personal injury cases. So I think the courts are going to construe the legislation to mean a DBA comes into existence if the primary payment obligation is bears a functional or mathematical relationship to the amount of the damages. So, your common or garden, if X happens, you pay me 25% of your compensation. That's a DBA. I think things which are at a further remove, like a kind of non-recourse arrangement or damages-based cap, the courts or the CAT are very unlikely to find that creates a DBA. Famous last words.
To be fair to Alex, I don't think you're differing from him. He didn't really express a view, certainly in our PodCost on the last occasion. All he was saying was this is the sort of argument that defendants are going to be coming up with, or he knew were already coming up with. I don't know what his actual views are. Anyway, perhaps enough of PACCAR for the moment. It seems to run and run, and where would our podcast be without PACCAR? Wanted to move on to interesting Court of Appeal decision in Churchill and Merthyr Tydfil.
Yes, this is a bit of a sore point for me because I was meant to get that brief, and somebody wouldn't release me from a hearing in front of a master where I think I spoke for precisely 3 minutes. So I felt very doleful when I saw my good friend Rob Weir, who stepped into my shoes, getting 3 days in front of the Lady Chief Justice, the Master of the Rolls, and Lord Justice Burse. So there we are, licking my wounds. Thank goodness I've got all the advice about PACCAR to console me. But it's an interesting case. So it's a Japanese knotweed case. The chap lives next door to land owned by Merthyr Tydfil Borough Council. He says that as a result of their failure to control weeds, Japanese knotweed is sprouting onto his territory. As somebody who, as a child, has vivid memories of my father ranting about Japanese knotweed sort of invading our garden, I have every sympathy with Mr. Churchill. I have to say, if he wants to fight Merthyr Tydfil Borough Council on the beaches or in the sea or the air, he has my support. So what Merthyr Tydfil say, and it's all a costs argument really, is don't litigate. Use our internal complaint scheme. Don't and it's unreasonable to have litigated before using our internal complaint scheme. District Judge in the Cardiff County Court holds that he cannot stay the litigation because of the decision of Lord Justice Dyson in a well-known case, or formerly well-known case, called Halsey and Milton Keynes. Essentially the message in that case was it would be Article 6 non-compliant for the court to stay cases and force people to mediate or conduct other sorts of ADR because of the right of access to the court. That was a controversial decision at the time. I think subsequent decisions of both the Strasbourg Court and the European Court, that's the Court of Justice of the European Union, have suggested, in fact, there isn't a incompatibility with requiring people to exhaust other remedies before you go and start litigating. And so the main thing this case decides is that Halsey is departed from. The court does have power to stay proceedings and oblige people to engage in ADR. I don't myself find that very surprising either, given the ever greater focus on pre-action protocols and requiring people, for example, to exhaust those before they can litigate. And of course, under many pre-action protocols, there are steers to explore ADR. For some time now, it's been within the civil procedure rules that the court has the power at least to encourage, I think is the verb that used, to encourage the people, to encourage the parties, to use ADR. And when you remember that the Master of the Rolls was involved, who's got some very well publicised and trenchant views on this, I don't think anybody was at all surprised to see Halsey overruled, so the court can do this. Churchill doesn't really go much further than that. It's not a long judgment. It is not a judgment which gives a vast amount of guidance as to when a court should stay, and says that will really need to be worked out in cases one by one. And it specifically does not reverse the district judge in not ordering a stay on the facts of that case. And I certainly think, as is not infrequently the case that's got up to be the test case, in fact, turns out to be quite atypical, because I think there really is a profound difference between staying a case to require people to submit matters to a skilled and neutral mediator is probably the classic example. The saying, you have a duty to use the internal complaints process Merthyr Borough Council, where your complaint would just be determined by an employee of the council. You aren't allowed lawyers, you can't recover your legal costs. And when you actually look at the internal complaints procedure, it's actually really been designed for people who want to say, you know, bloody hell, Merthyr, you haven't collected my bins again for the 6th week running. It's not been devised as a true dispute resolution process. So, and I think that's probably one of the reasons why the case, it doesn't, notwithstanding there were, you know, about a dozen interveners, it isn't a case which gives much guidance, because the practical scenario that before the court was so highly atypical, as a sort of internal council complaints process that, you know, is in no sense a kind of classic species of ADR. So I think it's probably, you know, the first case in it's probably the first case of a number of cases where the consequences of the decision would need to be worked out. And all it does establish is that in principle, a court can essentially compel parties to exhaust non-litigious remedies before it will allow them to litigate at, you know, at very great expense and, of course, the cost of the public purse.
Yeah.
I mean, obviously, you know, one of the, I think, things that is not mentioned about ADR is it essentially is privatizing dispute resolution, because, you know, ADR processes are not conducted by people who are paid by the government like judges. And at a time when the resources of the court system are very low, I think one would be, and I don't in any sense mean this pejoratively, I would think, you know, I think one would be unrealistic to suppose that concerns like that, you know, aren't playing on the judiciary, in addition to the natural desire to want to encourage parties to resolve their difficulties at minimum expense.
Andy, any take on this?
Well, I think it's that's a really helpful explanation of it. I'm tempted to just, you know, answer it like a lazy student who decides to write, you know, all he thinks about a compulsory ADR, and of course, sometimes it's a good idea and sometimes it isn't in my sort of book. But no, I do understand. When I think some while ago we were involved with some cases that were to do with alleged mis-selling by banks of certain things, and they were very keen to put complainants through their own sort of very neutral scheme for dispute resolution funded by them, and there was a natural reluctance of certain complainants to do that, and to go through that unless they were going to be represented and get that paid by the bank, that they didn't want to do. So that it never got to the point, or in the cases we were involved in anyway, of the court actually intervening in that and having to take a judgment on whether they should be made to do that or not. I just, to my way of thinking, I like what Ben said about the dangers of almost sort of privatization of this. For me, ADR is there where you know that the resolution by the courts is going to take longer and be hugely more expensive, and there's an opportunity to cut to the chase and maybe have a 2-day mediation instead of a 12-day trial. That I get, but in smaller cases, I don't see why that should necessarily be the case, because it adds to, one way or another, it adds to the cost. We're very commonly in a situation where one of the parties in cost litigation is sort of weaponizing ADR. You know, if we don't go through this stage, then, you know, we're going to bring your conduct to the attention of the cost judge if it ever gets there, sort of stuff. That is something that can just add another cost of a procedural step. Depends on the dynamics of a given dispute, of course. So hard to legislate about it.
Well, we see that work out presumably in decisions which follow it, because I imagine there'll be a number, at least to try and resolve the practical application, which the Court of Appeal deliberately said it wasn't going to do.
Yeah.
I was quite, you talked about the number of interveners, Ben. I was quite amused to see that at least 2 of the leaders were older than me, so I really have retired much too early, I thought.
Yes, I saw.
We all said that, Jeremy. We all said that.
We all said that. I did see Edwin Glasgow making all sorts of valedictory remarks about how it would be his last time in court and so on.
Oh, really?
Which I think at first the Lady Chief Justice found quite charming, but after a few minutes, I think she was getting slightly sort of keen to crack on. But there we are.
I feel a sort of James Sutherland repeat though there. I'm not sure that Edwin's going to be retiring.
No, he's like how many sort of farewell tours of the Rolling Stones, exactly.
Yeah. Anyway, moving on to something which is not terribly exciting, but just needs a brief flagging. Guideline hourly rates.
Yes, so the government has, well, I suppose strictly speaking, the courts, but I dare say the Ministry of Justice has to approve it, have confirmed that they will promulgate an increase in guideline rates. They've been told us how much it's going to be. They've essentially applied an inflationary measure using the service supply index, so not the sort of familiar RPI or the CPI, but index specifically linked to a provision of business services to uplift all the guideline rates. And they've also, I appreciate it's probably not so much your demographic of this podcast, but also the fixed costs. So, to that extent, obviously, welcome, because the guideline rates were promulgated in 2021, but the research they're based on was conducted in the middle of 2020. And the value of money, sadly, has diminished quite a lot since then, double-digit inflation for at least 2 of those years. So it needs to be done. But what they haven't done is address what a lot of people are saying needs to be addressed, which does seem to be the complete disconnect between the guideline hourly rates for first-class commercial work and the rates which are in the real world attainable in the City of London and Docklands and the other, and the other centres of heavy commercial work. Because I think the increased rate is about £542 for a partner, grade A, and I save maybe for the absolute largest corporate behemoths who, through volume of work, can really grind the price down. You simply do not see rates of that sort, even for sort of blue chip companies who, are big and ugly and can look after themselves. They just can't get them. I mean, certainly I appreciate that shedding tears for people who can afford to pay an Enchanted Circle firm £800 or £900 an hour. It's not the most obvious point at which to get out your violin. But on the other hand, it does seem to me to be quite unsatisfactory that they go to court, they win, they haven't done more than incur the costs which are out there in the market, and the courts just say, guideline hourly rates, essentially, you're going to take an immediate haircut of £300, £400 an hour on every hour your solicitors works. I mean, it's pretty devastating, even for a very wealthy litigant.
Well, then, in detailed assessment, it seemed that the risk is less than with summary assessment. And certainly cost charges are more.
Which makes no sense to me whatsoever. I mean, the idea that they should be, obviously summary assessment is a brisker method, but I mean, the idea that the principles to be applied are different is bizarre. And you get even cost judges saying this. I did a consequentials hearing the other day in front of Master Leonard, and he actually said, well, if this had been a detailed assessment, I'd have allowed more, but because it's a summary assessment, I'm allowing guideline rates. And no one yields in admiration to Master Leonard more than me. I think he's a tremendous, extremely careful judge. But with great respect to myself, well, that just doesn't make sense. How can that possibly be right?
Yes, it must be wrong. I agree with that.
I mean, the point about guideline rates, Andy, is they are there to help judges that don't have a sense of what the market rates are.
Yes.
But it's not within the power of a committee to set the market rates. They are meant to reflect the market rates, and if they're failing to reflect the market rates, that's a problem. And the function of the cost judge, and this is like House of Lords authority, Lord Hoffman in Callaway and Gray, the function of the cost judge is to allow work which is reasonable, having regard to what would be charged by generally in the market by people doing comparable work. And if you look at the guideline rates, and perfectly well, they are not discharging that function, then for my part, it seems to me to be a plain error of law to be applying them. But the message from the Court of Appeal is stentorian. Case after case now, they seem to be saying guideline rates. They in fact go further than the guideline rates themselves, because the guideline rates themselves say that for heavy, commercial work, there may be significant uplifts, at least at grade A, B, and C level. But you don't get the sense of that from what's been falling from judges in the Court of Appeal in the last 2 years.
No, I agree. I mean, historically, I've seen a few examples of the other end of that, which is actually some summary assessments with the firms getting much higher rates than they would get on detailed assessment, just in the exercise of judicial discretion, saying, well, look, you're charging as much as the other side. Why should I be interfering with that? I know some years ago now, but remember Carter used to bring a sort of compendium of all their rate decisions around to back up their arguments. Exactly. And charming though that was, but all the high points tended actually to be summary assessments by judges rather than cost judge decisions there. So we used to have to sort of fight it from the other side.
Well, I mean, certainly, I think you're quite right. I mean, particularly under the old guideline rates, I think a lot of judges in the commercial courts and the TC just said, well, these rates have got nothing to do with our world. And as you say, if this is what the parties have gone out into the market and this is what they've been able to get, this is what they'll recover. But the message from the Court of Appeal in cases like the Samsung case has been very clear that even in heavy commercial cases, what might have been true about the old guideline rates isn't true of the new ones. But they just don't address. Okay, but that's all very well, but unless you are saying that the law has changed and the rates you recover are no longer a reflection of what you can actually obtain in the market, then there's a serious question in my mind, not only about the correctness of what's being done, but really the virus of what's being done.
Yes, indeed. Yes, I mean, I think we're always in this. There's a tension between the principle which we've always thought is the one they should be adhering to, which is they should be reflecting costs that are incurred out there rather than trying to set them or discipline solicitors into charging them. And I also I think a point you've raised before, Ben, either formally or informally, that there's a true market at the higher end for commercial costs. There's real clients paying real money, and there's certainly sophisticated clients. There was far more concern when there wasn't that tempering in certain types of cases where always worked on CFAs. Client was never paying, and therefore it really was a claim that would be put as high as you could.
Yeah, I mean, it is a tremendous irony that the area of the market where there is probably A, the most competition, and B, the most powerful and savvy clients, well able to negotiate their corner, is the area of the market where the guideline rates are completely failing to permit the recovery of rates which parties have to incur because they just cannot get the rates which the guideline rates contend exist out there. Whereas as you say, in other areas of the market where there is in fact not a market at all because people are on no win, no fee, you aren't facing this problem. It is frankly rather frustrating. And even under the Jackson reforms, yes, you can depart from market rates if costs are disproportionate, because we know that if costs are disproportionate, they may be disallowed, may be discretionary, even if they're necessary. But in big commercial cases, there's very rarely an issue about proportionality. So even applying the sort of harshest measure of recovery known to inter-parties assessment, if the costs are not disproportionate, you are meant to get what's necessary. And if guideline rates aren't reflecting the necessary rates because they're less than market rates, then in my view, they ought to go out of the window.
Yeah.
But it's a minority view.
Yeah.
I was interested in the announcement of a working group to examine the methodology underpinning guideline hourly rates, which I thought was something they've been trying to do for the last 15 years with, singular lack of success. It's a bit like the government's attempt to control immigration. It's something that people have tried, time and again, and it never really seems to come out satisfactorily, in the sense of coming up with a methodology which everyone thinks, yes, that's absolutely right.
I know. I mean, again, it's ironic, isn't it? Because the reason it doesn't work is precisely because in many, if not most areas of practice, there's not a true market because of the impact of no win, no fee and things like that we've been discussing. Again, ironically, the one area of practice where there is masses of data available is in the context of commercial work, because there is a market and the rates which are being paid are not no win, no fee. They're mostly rates the companies in question, are being billed every 30 days. So, all the government needs to do is introduce a requirement that every cost budget and every summary assessment schedule, or every schedule that's filed, looking for a payment on account in the business and property courts, has to be copied to a sort of data collection team at the Ministry of Justice. And within a few months, they will have masses of data about the hourly rates which were actually available out there. But nobody does that. Might sound too much like common sense.
Moving on from common sense
Okay, quick.
to not common sense, the Solicitors Act.
Yes. That's a very,
the-
very skillful segue, if I may say so, because it truly is.
Yeah.
Yeah, it truly is certainly divorced from modern commercial practice and therefore not common sense.
Well, the MR expressed the view that he hoped the CJC could do something about the future of the Solicitors Act, which, quotes, really requires a generational look. I think it's more than generational. It's secular. It's centuries old, really, the overall approach to the Solicitors Act.
Yes, I mean, exactly. I mean, large parts of it, the language is somewhat modernized, but quite a lot of it is pre-Victorian. You know, you can actually sort of trace it back through to statutes. Certainly, I mean, large parts of it are Victorian, and I think there are provisions of it which you can clearly trace back, just with some modernization of language, you know, back to Hanoverian times. I mean, the main issue I think with it is, and I do actually think some of the problems are overstated. This sort of people sort of hyperventilating about the difference between contentious and non-contentious costs always strikes me as, who cares? You know, I mean, what difference does it make if you go to an assessment of costs which have been incurred after a trial, or if you go to an assessment of costs which have been incurred where a case is settled pre-proceedings, but on terms that costs are paid, you'll find the cost judge assessing them precisely the same way. But there's no kind of magic difference because one lot's non-contentious and the other lot's contentious. So I do think actually it's, you know, people are looking for problems where they don't always exist. But I think that the area where there is a really stark issue is around control of costs between solicitor and client, because it all is predicated upon a lost world of solicitors only billing their clients at the end of cases, you know, maybe taking some money on account, but not interim billing, you know, sort of stepping back at the end of the case. And of course, that's the old world also swept away for the best part of 25 years, where, you know, it's not until the end of the case even the hourly rate gets decided, because you add your B factor to uplift your A factor. So it's all sort of redolent of a world that's gone, where clients agree contractual terms in advance, and certainly outside sort of PI type work, solicitors are billing their clients, you know, monthly. So, you know, I think all that, you know, does need to be looked at. It is ridiculous that the timetable, if you want to challenge your solicitor's bill, you have to do that within a month, which, you know, if your solicitor's billing you monthly, it basically means you need to start a litigation against your own solicitor, you know, in the middle of in the middle of something where you want to work with that solicitor for the next 3 years, you know, unless you can agree a limitation amnesty. So, you know, there are parts that need to be looked at, you know, even though I'm skeptical as to whether or not the problems are quite as bad as people say in, you know, around some of the more arcane areas like contentious versus non-contentious costs.
I'd agree. And I think the issue of sort of statute bills and interim statute bills and all that is a minefield for everybody. And certainly if something could be done about that, it would probably be an improvement.
Yeah, well, it's also the classic thing, isn't it, when you don't have an updated law. So the law departs from modern commercial practice. So judges, you know, then become quite reasonably, you know, very tempted to try to devise solutions which ameliorate the problems which are resulting. And so you now have this, I mean, to my mind, utterly ridiculous corpus of cases. It must be, you know, sort of 6 inches thick, involving decisions mostly at a cost judge or high court judge level about whether or not a bill is actually a bill. And I have to say, I did a case recently where I did say to the judge, only a cost judge could look at this and say it's not a bill, because it was obviously a bill. It was headed bill, it itemized the work done, and at the bottom it didn't sort of say 50,000 on account, please. I mean, it said, you know, this is what you pay for this period to 2 decimal places. It was obviously a bill, but the cost judge wants to find it's not a bill, because you know, otherwise the client loses their right to detailed assessment because they didn't challenge it within a month. And so you get all these, you know, and so the law becomes ever more convoluted, and you have ever more disputes about, you know, is something a bill or not, when of course it's a bill, you know, but in the world of the distorting mirror of the cost judge and the high court judge that pays deference to them on appeal, no, it's not a bill. So you know, I think for that reason alone, it would be very nice if it could be attended to. Although, you know, since we are in the last year of the government, And if, as people expect, there's a change of government, you might think reforming the Solicitors Act, it wouldn't be the first priority of a Labour government after a decade and a half in the wilderness. I would think it's anybody's business, anybody's guess as to what will actually happen.
Yes, I think, like a lot of these things, I think people have to have the what's the modern phrase, bandwidth, I suppose, to look at it and the interest in doing it. I hope when they do, that some of the practical issues are that happen on current Solicitors Act assessments are dealt with at the same time, because I mean, from my point of view, it would be exceptionally helpful, irrespective of whether some things, a series of mini final bills or payments on account or whatever they are deemed to be, that if a client's going to be allowed to challenge a solicitor's bill, they ought at the earliest stage be forced to say, so what would you pay then? Because, because they tend to avoid that question until the death.
And obviously, there are all sorts of procedural absurdities as well. I mean, we live in a world where, you can lose both your legs in a road accident. And if you manage to get into the High Court at all, you'll never get a High Court judge. You'll get a deputy or something because, it's, on the great scheme of things, it's only worth a few million. In a solicitor-owned client dispute, the county court has got no jurisdiction unless the proceedings were actually conducted in the county court. And if they were conducted in the county court has jurisdiction so long as the bill is less than £5,000. I mean, it's absolutely unbelievable.
Yeah, exactly.
I think on that wonderful note, we can probably stop, just reminding us of the absurdity of the world in which we all work. Thanks again so much to Ben for that really lucid explanation of these issues that we've been talking about. Anyone who wants to see this again, or perhaps more likely recommend it to someone else, can find it on the sites that Andy mentioned at the beginning. And it remains simply to say thank you all very much for watching.
Thank you very much. I don't. Is this going out before Christmas? If it is,
it is.
Happy Christmas. If it's not, Happy New Year.